Well, be careful what you say. And it's not your fault.
Oh, I know it's not my fault.
It's not your fault. Quit laughing.
All right. Record should reflect at a bench conference in this case. Really, there's a motion by the people to modify his bond.
And that's correct, Your Honor. It's our understanding that this case was picked up while the defendant was on bond for another case involving controlled substance delivery and manufacturing, as well as probation in circuit court. And I believe per the statute, he should have been given a surety bond. So this time I would be re-requesting our original request of $50,000 cash surety. However, I understand the court. Thank you.
And Your Honor, we do understand the people's concern as well as what the statute states. However, my client has been out on bond on this case with absolutely no issues. We know that there is another case. He was present for his preliminary examination on Tuesday for that matter. I believe that the issue of bond was addressed at that time and the judge put him on a home confinement tether GPS. That was Tuesday. He does have that tether on to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
Right. I would find that the setting of a personal recognizance bond under the circumstances was use of discretion by the magistrate. Setting bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other thing. But since that point, he's been cooperative. He's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter. At least that way he can post it. I will also set the, you want this set for preliminary?
Yes, Your Honor, please.
And your discovery is complete?
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available to 17?
We are just waiting on the final call.
Pardon?
I requested the 911 call, but I have not received it yet.
Okay.
We're fine. Proceed.
You're willing to proceed?
That's right, Your Honor.
All right. Preliminary examination in person, March 17, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you.
This is a typical bond modification hearing where the judge has to balance two sides. The prosecution points out that the defendant allegedly picked up this new case while he was already out on bond and on circuit court probation. That makes it harder for the defense to argue that he should remain on personal recognizance. The defense takes a different approach. They focus on what the defendant did after the new case started. He appeared in court, accepted GPS home confinement, and followed the conditions that were given to him. Because of that, the judge had a reason to reject the prosecution's request for a $50,000 cash bond. Instead, the judge set a $10,000 bond at 10%, which could require a $1,000 payment. Did you notice that the judge recognized the alleged violation, but still gave credit for the defendant's cooperation afterward? That does not mean the new allegation disappears. It simply shows that a bond hearing is about managing risk, not punishing someone before they are convicted. The judge's decision to remand him means he stays in custody until the bond is posted or the court gives further instructions. The big question now is whether his recent cooperation shows that he will follow the rules in the future, or whether he only started cooperating after another serious case was filed.
Kareem Johnson, on behalf of Mr. Poole, this is the co-defendant case, Your Honor.
Yes. And
He's going to be
the next in. Your name, sir?
I'm cool.
All right. What are we doing on this?
Your Honor, we're setting this for exam, and I would like to address my client's bond.
On the, who has the co-defendant?
Mr. Burgess, that's.
Is that going to be the same position on?
Saying for exam, Your Honor?
Yes.
That's correct.
All right. And Mr. Johnson, you're not available the 17th.
That's correct, Your Honor.
All right. So I think I said his other matter for the 31st when we looked at dates. Will that work for you, Mr. Burgess?
That's fine.
Is that okay? So who's what are the numbers?
I updated your shift for the 31st. You've got to Washington.
Well, we'll just start loading her up at some point. I'll set preliminary examination in person March 31st, 2026, 9 a.m. before Judge Washington. All right, as to bond.
Your Honor, my client does have significant family support. His mother, his brother have been in constant contact with me. He does have a place to go and responsible people to make sure he will abide by any bond conditions. We concede that allegations made in this case are serious. However, I don't believe, other than a picture taken over an hour after the incident, there's no electronic, scientific, or personal identification that places my client at the scene of this crime, conducting any crimes, Your Honor. So because of that, we'd ask for a significant bond reduction to $15,000 cash, surety of 10%.
Current people would object to any change of bond at this time. The basic allegations here is that the defendant, along with the co-defendant, fired at an occupied house. My understanding is that that house had previously been occupied or owned by members of a rival gang, and that this was a gang-related shooting. The members or the individuals in that house were not really with that gang, completely innocent, is my understanding. But the defendant, the co-defendant, fired, I believe it was 25 rounds into or at that building, including some of those rounds being fired by a fully automatic weapon, some of those rounds being fired by a rifle. I have significant concerns for public safety. If the defendant is to be released now, I'd ask that bond remain as set.
I guess the only concern that I had is Mr. Johnson indicated there is evidence that connects this defendant to this crime, I'm presuming.
Yes, it's a lengthy report. I can go through and try and find exactly what evidence that is, but I can have just a second.
Well, that's okay. It's just, it made it sound as though there's no evidence that connects this individual, but that's not what the people's position is.
Correct.
At this point, given that exam would be pending, I'm going to deny the request for a change in bond. Bond will continue. All right.
Yes, sir.
Thank you. Thank you.
This was the biggest evidence dispute during the hearing. The defense argued that, apart from a photograph taken more than an hour later, there was no electronic evidence, scientific evidence, or eyewitness identification directly placing the defendant at the shooting. That was an important argument because the defense was separating the seriousness of the shooting from the question of whether this specific defendant was actually responsible. The prosecution described a very serious incident, alleging that around 25 rounds were fired into an occupied home. They also mentioned a fully automatic weapon and a rifle. But when the judge asked what specific evidence connected this defendant to the shooting, the prosecution did not immediately provide a clear answer. Does that hurt the prosecution's case? It certainly left the judge without a complete explanation of the evidence. But this was only a bond hearing, not the preliminary examination where the evidence and probable cause would be tested more fully. Because of that, Judge Simpson kept the existing bond instead of making a decision about the identification evidence at this stage. The defense also showed that the defendant had family support, housing, and supervision available. Still, the judge considered the alleged danger to the public and the fact that the evidence described in the police report had not yet been fully tested. So the next hearing could be very important. The prosecution will have to show how the evidence actually connects this defendant to the shooting.
Versus Willie Collins.
Morning, Your Honor. Raymond Cook for the people.
On behalf of Mr. Collins, Your Honor, did you get my green sheet?
I did.
So we're requesting an adjournment.
has to go. Okay. I have a violation, however.
Yes, I shared it with him.
How come he hasn't gone?
Your Honor, there was some miscommunication when he was released. And he has a plan now. He lives on Berkshire. He has a plan so that he can, and he'd be clean today if we were to test him.
But he hasn't been over to test.
Well, he knows where it is now.
But he didn't know before?
No. He just said he didn't know where it was, Your Honor.
Well, why didn't he find out?
Well, be careful what you say.
I mean, he hasn't tested at all.
Well, he'd be clean right now.
Well, but he hasn't tested at all while he's been on release.
That was from what, the 24th, so it's not like it's a couple months.
So he just didn't go.
Well, he didn't know. That's my information.
He didn't know what?
That he was supposed to go. Well, be careful what you say.
Your Honor, when I was talked to by the magistrate, I just got Jackson County doing a year. I'm on probation in Jackson County. So the magistrate told me that I can test when I go report. I just reported Monday.
He told you what?
That I had to reply with Jackson County's probation.
Comply with Jackson County probation. He means, I think he has tests as a condition of his probation in Jackson County. So Jackson County.
I don't have any record of that. Not written over.
That's what he's representing. His information and belief when he was arraigned that he could substitute the testing in Jackson County here. That's all. And there was a little miscommunication on his part. So.
But he hasn't. Have you tested in Jackson?
Yes, sir.
When?
Monday.
When?
Monday, sir.
He'll sign a release right now if you want.
Well, he needs to get over there and do all of that. But I'm not going to have a circumstance where we tell him to test and he hasn't even gone over there and reported.
But he's testing at another.
He hasn't reported and hasn't been in contact with our community corrections.
Well, he's prepared to do it right now. He's just being double dipped, testing two places. That's all. And it's not your fault. I
know it's not my fault.
It's not your fault. Quit laughing.
March 26, 2000. I'll set his adjourned probable cause to March 12, 2026 at 9 a.m. But at this point, defendant's bond is revoked. Defendant demanded.
Now he's going to get in trouble in Jackson.
I didn't do it. I just did my job.
Final hearing shows why bond compliance is based on what a defendant actually does, not simply what they say they would do. The defense said the defendant failed to report locally because of a misunderstanding. He believed that testing through Jackson County probation would satisfy the requirement in this case. He also said that he completed a test there on Monday. But Judge Simpson kept coming back to the same issue. The defendant had not reported to the local community corrections program, had not made contact, and had not completed the testing required by this court. The defense offered to sign a release so the court could verify the Jackson County test result. That was helpful, but the offer came only after the judge questioned the violation. The comment about being double-dipped also created a problem because it could sound like the defendant was minimizing the court's authority. Different courts can have different requirements unless one court specifically approves another arrangement. Did you notice how the judge warned everyone to be careful, especially when laughter entered the conversation? In a bond hearing, behavior like that can make the court question whether the defendant is taking the conditions seriously. Across these hearings, Judge Simpson handled each situation differently. One defendant received a financial bond after showing some cooperation. Another did not get a reduction because of the serious shooting allegation and unresolved identification evidence. In the final case, the bond was completely revoked because the defendant could not show that he was following the required conditions. The lesson is simple. If a court gives you conditions, make sure you understand them, follow them exactly, and keep records to prove your compliance. If you found this case as shocking as we did, hit the like button, share your thoughts in the comments, and subscribe for more courtroom breakdowns.